Judgment imesomo in this case of Willie Kimani. The court has convicted 4 to release 1. I have had judgments before. I've listened to judgments before. I've seen cases before. But if I do not show my displeasure and my unhappiness in the kind of judgment that we've had today, then I'll not be honest to myself. This is a case whereby this court imported evidence, discarded evidence, did not consider evidence, and most of all, did not follow procedures properly. It's a quote from the word go after it came in after the second judge. We believe, and this is my honest belief, I cannot shy off. I had my doubts about it. But when somebody has been convicted based on a conviction, on a confession that the court wants to rely on partly, and then say that the second confession that he was making in court when giving his evidence could not have been true, but then take a part of it to rely on it and say it's an accurate report of events, then you begin to realize that this court is actually wavering between evidences. Let me start with the second accused person. The second accused person in this case never gave evidence that was unsworn. It was sworn, he was cross-examined, he was tested, and he was good. I believe the court could not have read his defense in considering this judgment. Why? Because the court has come up with a conclusion that he gave an unsworn statement, his sworn evidence was unsworn, and that he could not have been cross-examined on material facts. It is a lie. The guy, the accused person was cross-examined by all officers of the court who were there on that day. And the court places the radio in his hands when he has never had a radio. Where did the court get that evidence? And saying that he had the radio, and the radio went off. The court also says that the accused person was in all material areas. When evidence from the OB and other things show that he could not have been on duty, when the court says he was on duty, the duty also shows he was not on duty. And the only time that he could have spoken to any of the people at the court on that, at the Syokimau police post, was when he spoke to Sylvia. The court says that he was at all scenes. When a mast is here, it covers an area of more than 2 kilometers either way. So if I'm here, can the person say that I was also at Pan-Africa? You cannot. So how does the court conclude without any evidence that the second accused person was at all these scenes? It's a lie. The people are kidnapped at midday, according to data, which the court is relying on. But my client's data shows that he was passing that crossing at 10. It's a road. It is a road. He was passing through there at 10. Before the people leave the court, before the kidnap is done. And where does he go? He goes to meet Sylvia, the third accused person, and they go to City Cabanas. But he's not there. He's not at the kidnapping. He's not at the court. And then what happens after that? He goes home and sleeps. If he's not on duty, did he need to go to the cells? No. Could he have seen the victims? No. Did he have a reason to go there? No. The court says that he's guilty. Of what? They say that his radio, his phone was also switched off. How do you say his phone was switched off at 8? When it was switched off, where exactly was this phone switched off? At 8. In his house. On a night that had rained and there was no power. Do you put consideration that there was no power? The court does not do that. Why are you placing him at the murder scene at Mastermind when you can see that the data shows he's in his house? Then the court again comes and says the first accused person was not at the scene in the morning hours. Those morning hours that you are saying the accused person was not on the scene, but you want to put the radio in his hands. At 9, the radio is at Mavoko, Lockots. At 10, the radio is at Mavoko Locals. At 11, during the time of the kidnap until 12, the radio is at Mavoko Locals. The court has established that my client was at Mbagathi. It has established and proved, and evidence has been given. Witnesses and the commanding officers have come and seen and shown evidence that he was there. This radio was active there. How do you place that radio in the hands of the accused person during that morning? At what point then do you want to place it in his hands in the afternoon? Because in the afternoon, he comes back at 1, he goes home. He stays with his wife, who has proved that. He stays in the house until 4:50 when he comes out and goes to meet one of his commanding officers. In between that time, the radio has been moving in from Syokimau to Mlolongo police post. To Mlolongo police station all along, while my client is in his house. Where was that radio? Who had it? The benefit has been created. The benefit is already there. So when the radio is seen at 18:40 to 7 p.m., a span of 20 minutes, at Syokimau police post, my client is not there. At 7 sharp, my client is at Mlolongo police station doing what? Picking summons and documents to go and pick up a witness from Makindu. At 19 onwards, the radio is seen where? At the mastermind, the place they call Soweto. My client is in his house with his wife. Their data is linking. Wako nyumbani. So how do you do? How does a court ignore all this? This is a case of murder. This is somebody's life, and it's supposed to be proved beyond reasonable doubt. Is that beyond reasonable doubt? It cannot be. It cannot be beyond reasonable doubt because the court has intentionally left out evidence that exonerates the client and picks on what she thinks can work. But still, it does not work.
So the upshot of this is that the judge misapplied the law.
The judge not only misapplied the law, the judge did not even look at it. The judge did not even look at the defense. When you create a defense for my client and say this is what my client said, when my client did not even take that route, then you must be importing evidence and creating a scenario so that you can convict him. When you say my client gave unsworn statement in his defense, when my client was crossed over and was cross-examined, then what defense did you read? What defense did you read? You did not read the defense. You did not apply the law. You fixed things in his hands just to convict him. Why? Is it because of pressure? If you are a judge and you are going to do your work, better do your work because you are doing it properly, not because of pressure. You cannot go and start saying that my client had a motive when my client has done his duty as an officer of a police officer. He arrests somebody who is gambling and has bang and all that. The guy comes up with you at a knife. That was proved. The knife was an exhibit in court. You shoot the person in the hand. Then what does the court do? Says that there was a P3 form showing that the person had injuries in the chest and upper arm. The doctors we waited to come and testify did not. Why did the court admit that document? At what stage when we had objected to it? Then what happened? The doctor doesn't come to support that. Johansen Odur comes to court. He has a postmortem report. We ask him clearly, please tell us where their injuries are apart from the head and the strangulation on the other part of the body. The only place that had an injury is the wrist. Showing what? My client was saying the truth that he shot the guy in the hand when he tried to attack him with a knife. There is no other injury. So this other evidence was never supported by anybody else. It was never supported by anybody else. So it is all a matter of this court being under pressure, taking a long time to give a judgment so that you can try to support evidence that does not exist, believing in a confession statement halfway and choosing not to believe the other half. You see, when the court starts reading a confession and says this confession must have been correct, must have been true, it was only retracted, then you use the same confession to remove the fourth accused person from the case and say, oh, he could not have been at the scene. Why are you choosing what to pick in the confession and what not to pick? Because if the confession is true and you accepted it to be true as it is, then the evidence that is there on record is what you are saying is true. You use it to convict the first accused person, but then you don't use it to convict any other person. How does that stand in law? Then you pick what he has given in his testimony in his defense at the end and then say, oh, that testimony, he created other names, they could not have been true. But you still pick evidence from that to use it to convict in the first case. I think this judgment was just the most disappointing one, the most miserable one. And that is why you saw I took an issue with the judge and I told her in her face very clearly that you have created evidence against the second accused person. He never gave unsworn statement. And now you want to get out of the case, so that what happens? So that we start that process with somebody else? Take your baby till the end, so that when we want to complain about you, we complain about you. When we say that you did not read the evidence, it is a fact, so that we face you and tell you. So that when we go for appeal, we say that we even brought these issues to your face. How can you be functus official, yet you have not finished the job? Part of sentencing is part of it. When you're doing this case and you're coming to, I mean, when you want to do mitigation, these are the things that we shall raise. So this court cannot come and tell us it's functus official and then move out of it. She has done a mistake, she has done wrong, the judgment is totally bad. Actually, let me repeat, totally bad. It cannot stand an appeal. When you rely on data for the fourth accused person, you acquit him and say the data shows that he was not at the scene. My first accused person shows you data that shows he could not have been the scene. You choose to believe the fourth accused person he could not have been at the scene, but you choose to believe that my first accused person must have been at the scene. Why do you choose data to favor you and choose data not to favor others? It is selective. We will be appealing. Wacha tu alete hiyo sentencing kwanza, but we shall appeal.